The Supreme Court just dropped a bombshell 9-0 unanimous decision that completely rewrites how your Second Amendment and Fourth Amendment rights work together, and this ruling is about to change everything for gun owners across America. What happened in this case will shock you, because it exposes how courts have been systematically stripping away your constitutional protections during police encounters. If you care about your rights, hit that subscribe button right now, because this information could literally save your life. The hidden constitutional crisis. This Supreme Court case reveals a terrifying truth that most Americans don't realize. Over 1,000 people are killed by police each year during encounters where constitutional rights should have protected them. Yet courts have been using a broken legal standard that ignores everything leading up to these deadly moments. The moment of threat doctrine has been quietly stripping away your Fourth Amendment protections for decades, focusing only on split-second decisions while completely ignoring police misconduct that created the dangerous situation in the first place. Federal statistics show that 40% of police shootings involve cases where officers failed to properly identify themselves or violated standard procedures. Yet victims and their families have been denied justice because courts refuse to examine the full picture. This flawed system has been rubber-stamping excessive force cases across America, leaving citizens defenseless against police overreach. But here's what's truly shocking about how this broken system actually encourages the exact type of police behavior that puts both officers and citizens in deadly situations. The deadly police behavior pattern. Research from the Police Executive Research Forum shows that 23% of officer-involved shootings stem from traffic stops that escalate unnecessarily, and the moment of threat rule has been giving officers a free pass to create their own justification for deadly force. When officers make tactical errors like jumping onto moving vehicles, failing to use de-escalation techniques, or creating unnecessarily dangerous situations, courts have been ignoring these critical factors and only looking at the final seconds when officers claim they feared for their lives. Department of Justice data reveals that officers who receive proper de-escalation training are 15% less likely to be involved in shootings. Yet the legal system has provided zero incentive for departments to implement these life-saving protocols. The Barnes case perfectly illustrates this deadly pattern. An officer chose to jump onto a moving vehicle during a minor toll violation stop, creating a life-threatening situation that didn't need to exist, then used deadly force, claiming self-defense. What makes this even more outrageous is how this legal loophole has been systematically denying justice to families while protecting officers who make inexcusably poor tactical decisions. Second Amendment collision course. Here's the constitutional nightmare that keeps Second Amendment lawyers awake at night. Every year, hundreds of legal gun owners are killed or prosecuted when they defend themselves against unidentified law enforcement officers. And the moment of threat doctrine has been making it nearly impossible to hold officers accountable for failing to properly identify themselves. FBI statistics show that no-knock warrants have increased by 300% over the past 2 decades, with nearly 20,000 executed annually, creating countless scenarios where armed homeowners face split-second decisions between exercising their Second Amendment rights and potential death or imprisonment. The most disturbing cases involve plainclothes officers or raids at wrong addresses, where law-abiding gun owners defend their families against what appears to be home invasions, only to face murder charges when the moment of threat analysis ignores the officer's failure to announce themselves or verify the correct location. Constitutional scholars have documented over 50 cases in the past 5 years where Second Amendment rights directly conflicted with Fourth Amendment enforcement, resulting in tragic outcomes that could have been prevented if courts examined the totality of circumstances rather than just the final moments. The two-tiered justice system exposed. The most infuriating aspect of the moment of threat doctrine is how it creates completely opposite legal standards for citizens versus police officers in identical life or death situations, and the statistics prove this bias is destroying equal justice under law. When a civilian uses deadly force, prosecutors examine every detail: their training, alternatives available, whether they could have retreated, their mindset leading up to the incident, and whether their actions were reasonable given all circumstances. However, when officers use deadly force, the moment of threat rule has allowed courts to ignore identical factors, focusing only on whether the officer subjectively feared for their life in the final seconds, regardless of how their own actions created the danger. Legal analysis shows that civilians face conviction rates of 43% in self-defense cases, while officers face conviction rates below 2% in excessive force cases, even when the factual circumstances are nearly identical. Research from civil rights organizations demonstrates that this double standard has resulted in over 400 cases, where officers received qualified immunity for actions that would have sent civilians to prison for decades. The qualified immunity loophole crackdown. Most Americans have never heard of qualified immunity, but this legal doctrine has been the secret weapon protecting officers from lawsuits, even when they violate constitutional rights. And the Supreme Court's Barnes decision just opened a massive crack in this seemingly impenetrable shield. Under qualified immunity, officers cannot be sued unless they violate clearly established law that a reasonable officer would have known. Which sounds fair until you realize that courts have interpreted this so narrowly that officers escape liability, even for obviously unconstitutional behavior. Legal databases show that qualified immunity has protected officers in over 70% of excessive force cases, including situations involving shooting fleeing suspects, using force on compliant individuals, and killing people who posed no immediate threat. The moment of threat doctrine worked hand in hand with qualified immunity by limiting the analysis to such a narrow time frame that it became nearly impossible to prove officers violated clearly established rights. However, the Supreme Court's requirement for totality of circumstances analysis dramatically expands the time frame courts must examine, potentially exposing officer misconduct that previously remained hidden. Civil rights attorneys are already filing new cases using this expanded analysis, arguing that when the full context is considered, officer violations become much more apparent and qualified immunity protections should not apply. The enforcement revolution beginning. The Barnes decision isn't just changing legal theory, it's already triggering a wave of case rehearings, new lawsuits, and policy changes that could fundamentally transform police accountability across America within the next 2 years. Federal court records show that over 200 pending excessive force cases have already requested rehearings based on the Barnes standard, with plaintiffs arguing that previous moment of threat rulings ignored crucial evidence that would change the outcomes under totality of circumstances analysis. Police departments in major cities are frantically rewriting use of force policies because they know the expanded analysis will scrutinize officer training, departmental procedures, and tactical decisions that were previously considered irrelevant to legal liability. Your constitutional rights transformation. This Supreme Court decision fundamentally changes what your constitutional rights actually mean during any police encounter, and understanding these changes could literally mean the difference between life and death, freedom and imprisonment for every American citizen. Under the new Barnes standard, your Fourth Amendment protections are no longer limited to the moment an officer uses force. Courts must now examine whether officers followed proper procedures, identified themselves correctly, used appropriate tactics, and exhausted reasonable alternatives before resorting to force. For Second Amendment advocates, this creates unprecedented opportunities to challenge cases where gun owners defended themselves against improperly identified officers, no-knock raids at wrong addresses, or situations where police created dangerous circumstances through poor tactical decisions. The practical effect means that evidence previously excluded from court, such as officer training records, departmental policies, radio communications, and witness testimony about events leading up to critical incidents, must now be considered when determining whether constitutional rights were violated. This 9-0 Supreme Court decision is revolutionizing constitutional rights protection and changing how every police encounter will be legally evaluated going forward. If you found this breakdown valuable and want to stay informed about critical constitutional developments that affect your rights, smash that subscribe button and hit the notification bell so you never miss these game-changing legal updates. Your constitutional rights just got stronger, and knowledge of these changes could save your life or freedom in a critical moment.